What is consent? It's an indication signifying agreement to processing. It's freely given, it's specific, it's informed, and it's unambiguous by statement or a clear affirmative action. The elements of valid consent: first, freely given, that is, provide genuine choice. Second, specific, that is, concise on the processing operation and purposes. Third, informed, provide clear information and in plain language at a minimum containing the controller's identity, the purposes of the processing activities, the right to withdraw consent at any time. The amount of information depends on circumstances and context of a case. Fourth, unambiguous, indication by statement or a clear affirmative action. A clear affirmative act such as I agree or I disagree. Consent cannot be derived from silence, pre-tick boxes, pre-completed forms, or inactivity. What are the conditions for consent? Controllers bear the burden of proof for establishing consent. An individual can withdraw his consent anytime. Consent is presumed not to be freely given if the performance of a contract, including the provision of a service, is conditional on consent that is not necessary for the performance of that contract or service. Example: suppose a customer has a contract with a bank for ordinary bank account services. In the contract, the bank imposes consent for receiving marketing emails from partners necessary in order to avail banking services. Hence, in this case, consent is considered to be not freely given. A case scenario: a customer agrees to receiving promotional mails to an address which he or she has provided to a controller. Should the customer withdraw his or her consent, the controller must immediately stop sending promotional mails. No punitive consequences such as fees should be imposed by the controller on the customer for withdrawal of consent. Your to-do list: you must ensure consent is valid. You must implement simple and easy to access ways to withdraw consent. You must keep evidence of consent: who, when, how, and what you told people. Notification of personal data breach and communication of personal data breach to a data subject. What is a personal data breach? It's a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. Examples: a person gains access to a controller's customer database and discloses the information to an unauthorized person. A controller is hit by a denial of service attack, causing disruption to the normal service and unavailability of personal data. An attacker modifies the database of credit information held by a company. When does a controller or a processor become aware of a personal data breach? Where the controller has a reasonable degree of certainty that a breach has occurred. Sometimes it may be clear from the outset, whilst at other times a quick preliminary investigation is required. Emphasis: take prompt and proactive action to investigate whether a breach has occurred or not. Example: a controller suspects that his network has been accessed by an intruder. he quickly verifies and finds that his data has indeed been compromised. What should a processor do when he becomes aware of a personal data breach? Notify the controller without any undue delay. What should a controller do? Notify the Data Protection Commissioner without undue delay and, where feasible, not later than 72 hours after becoming aware of it. Communicate the personal data breach to the data subject, where it is likely to result in a high risk to the rights and freedoms of the data subject, without undue delay after notifying the Data Protection Commissioner. What happens if a controller cannot meet the timing delay of 72 hours to report to the Data Protection Commissioner? Reasons for delay have to be provided to the Data Protection Commissioner. How to report a personal data breach? Personal data breach notification form is available on DPO's website. The nature of the breach, the categories and number of data subjects and personal data records concerned, the contact point, the measures to address and to mitigate the adverse effects of the breach have to be communicated to the Data Protection Office. Are there circumstances where communication to data subjects is not required? When appropriate security measures were already applied before the breach, such as encryption, which rendered the data unintelligible. When the controller has taken subsequent measures to ensure that the breach is unlikely to result in a high risk to the rights and freedoms of the data subjects. When it would involve disproportionate effort and the controller has made a public communication or similar measure whereby a data subject is informed in an equally effective manner. Your to-do list. Make sure you have appropriate technical and organizational protection measures to protect data. Determine whether to set up a breach response team. Review regularly and update all procedures for addressing breaches. Be careful not to destroy evidence that may be valuable in determining the cause or allow you to take appropriate corrective action. Determine whether any other external third party or parties need to be notified to limit the potential impact. Duty to destroy personal data. Where the purpose for keeping personal data has lapsed, every controller must destroy the data as soon as is reasonably practicable and notify any processor holding the data. Any processor who receives such a notification from the controller must, as soon as is reasonably practicable, destroy the data specified by the controller. Retention period must be defined by the controllers and processors by taking into account other laws as well, not only the Data Protection Act. Example: personal data may be removed from marketing list or database if data subject withdraws consent. If you have any queries regarding data protection, contact the Data Protection Office for advice.